77, People v. Baines.
May it please the Court, Joseph Nursey representing Donnell Baines. Your Honor, may I reserve 2 minutes for rebuttal?
Yes, Mr. Nursey.
Donnell Baines's case presents two fundamental issues of state and federal constitutional law. The first being the validity of the search warrant for Donnell Baines's home, and the second being whether he was properly allowed to proceed without counsel, without being given adequate warnings, and without an unequivocal request to represent himself. I'd like to first address the warrant issue. The invasion of a person's home is at the very core of the federal and
Is the warrant issue preserved?
Yes, Your Honor. It's preserved in a couple of different ways. The first is in the omnibus motion that was made by the original counsel in the case. And in the omnibus motion, he specifically argued that the search warrant was constitutionally overbroad and that it failed to describe with sufficient particularity the property to be seized. And then he goes on to talk about the overbreadth on the seizure of computer CD-ROMs and hard drives, and specifically says to allow detectives to seize these computers and then pour through all of their files with no allegation that the property was 1, stolen, 2, contraband, 3, used or had been used to commit or conceal a crime, or 4, constituted evidence of a crime, violates the CPL and the state and federal constitutional provisions. That's at A70 of the appendix. Then it went on to say, additionally, the search warrants are overly broad because they allowed unfettered discretion to the searcher, and specifically cited the court to People versus Bennett.
But with respect to the arguments that the defendant now makes on appeal,
Yes.
you're saying that that which was stated in the omnibus motion is sufficient to make those arguments here
Yes.
allowed to be reviewed by this court?
Yes, it's set out in pages 11 through 13 of our initial brief. But beyond that, Mr. Baines himself filed a motion to re-argue the denial of the search warrant.
Can preservation be established in the motion to re-argue?
Okay, under CPL 470.05, preservation can be established in any time where the court is given the opportunity to, in a manner in which to make sure that the error does not occur. And this certainly gave the court the opportunity to realize that its initial decision upholding the validity of the warrant was an error and needed to be addressed. An important thing about Mr. Baines's motion to re-argue, that motion to re-argue was filed with the court on January 25th, 2012. And the court told the district attorney, if you want to respond to these motions, you have to respond by February 15, 2012. The district attorney in the trial court made no response whatsoever to the motion. Didn't contest Mr. Baines's arguments for why the motion was timely filed, and didn't contest Mr. Baines's extensive arguments for why the warrant was invalid, which are the exact arguments that we're presenting to the court today. They didn't respond a word to it, and I don't believe they should be heard now to argue that it's unpreserved when they had all the chance in the world. The trial judge gave them over 3 weeks to answer and to express why the issues were not preserved by Mr. Baines's motion to re-argue.
But the original omnibus motion didn't raise the issues that you're raising now concerning overbreadth.
Not as specifically as Mr. Baines did.
Okay, but isn't that preservation?
Okay, the omnibus motion did refer the court to People versus Bennett, and People versus Bennett stands for the proposition that a motion that's facially, a search warrant that's facially invalid cannot be cured by affidavit of the detective that is neither specifically incorporated into the search warrant nor attached to the search warrant at the time it was executed. And he also argued about the overbreadth of the seizure of all the electronic data, all the electronic equipment and all of its contents. That was in the omnibus motion.
Right, saying they weren't evidence of a crime, but not necessarily saying that it was because a specific crime wasn't mentioned in the warrant, which is the argument today.
Okay, in the original omnibus motion, the council did argue that a valid warrant does require a particular crime being alleged. A valid warrant requires the allegation of a particular crime. Again, didn't do it with the extensiveness that Mr. Baines did it, but it was said in the omnibus motion. And when you look at the court's decision on the omnibus motion, the court extensively relies on the affidavit of the detective to find the warrant valid rather than what was on the face of the warrant itself.
Is your position that you always need the crime or only in certain circumstances?
I know there are federal decisions that have said you don't specifically need to like cite the crime and chapter and verse of the penal law or whatever. There has to be something that limits the behavior of the police officer.
I'm thinking more of the federal cases, and I think they're federal, that say you may need it. It depends on how specific your warrant is. So if you say, I want such and such a computer, or I want such and such an item, that limits the discretion of the searching officer, right? I'm going to go in and I'm going to take X. If it's vague, then putting the crime in the warrant or incorporating the charge into the warrant will limit the discretion of the searching agent in terms of what they can take, but not always required. It's kind of a balancing, looking at what's required, what the warrant says, and whether that's enough, or does it need to be informed by other outside?
If you look at the search warrant in this case.
No, but I'm asking you what's your position. Is your position that always, all the time, it has to be there, or it depends
My
on?
position is this court should adopt a rule that the crime should always be stated. But even if this court's not willing to go to that extent, if you look at the specific search warrant in this case, there's not a clue on the face of that warrant. Nowhere on the face of the warrant does it tell the police officers what crime they're looking for evidence of.
Would that matter if I said, go into this apartment and find X? That's what it says on the warrant. I give that to a police officer. They go into the apartment and they find X, a specific item.
If it
Would
were
it
just
matter
if it were
then?
just a specific item, there are some cases that talk like if the warrant says, go seize a gun, or go seize heroin.
No, but if it's
You know
not a
that- you know
per
those are
se
illegal.
crime to possess it, let's
okay.
say. But I just say, go seize a copy of, Rebecca. Like, go seize this item. And you
Okay.
go in the apartment, you have that warrant, there's the copy of the book on the desk, you take it and you go and you voucher it. What's wrong with that
Okay,
warrant?
if it just said, go seize X, it might be said that that specifically directed the behavior of the police officers who conducted the search and informed the subject of the search what they were invading their home for. Okay, but when you have like this, that says, seize every single piece of electronic equipment you can find in the house, and then after you seize, it's not just getting your hands on the hardware, the computers and the phones and everything else, but after you seize it, you can then search every single piece of data that's on these
But
phones.
what if you can seize it and you can seize specific notebook, computer X, version 23, you seize that and then later you get a warrant to look at the contents?
Okay, in this case, the July 15th warrant authorized both the seizure of the hardware and the ability to go and take all the data off of the hardware. Every single thing stored on the digital equipment.
Could I ask you to turn to the other issue for a moment? And
Yes, sir.
particularly what I'd like to know about is during what period of time you believe Mr. Baines was deprived of counsel without the proper cautions being taken, and what the remedy ought to be?
Okay. The period of time is from the November 3rd, 2010, where the court relieved his assigned counsel, all the way to just barely a month before trial when he accepted counsel for trial. And it covers the entirety of the pretrial hearings in this case. As far as remedy, he was deprived counsel, or did not have counsel, at the grand jury. And before that happened, on November 3rd, he received absolutely no warnings, none whatsoever, about
At the
proceeding pro se.
at the time that the court relieved counsel.
Yes.
Just prior to the second grand jury.
Yes, Your Honor.
Did the court at that time, when they were on the record, indicate that it was deeming the defendant to be pro se, or did the court say, we're going to address that later? I'll give you a new attorney, but we'll address it later.
What the court specifically said was the court discharged the attorney, and then said, we'll take up the question of whether a new attorney is going to represent you or whether you're going to be pro se and that person's going to ask a legal advisor. We're going to take it up the next day.
So at that point, arguably, the court has not made a decision that the defendant may proceed pro se. In fact, the court says 18B will be contacted to provide you with a new attorney.
Okay, if you look at what happened after, it becomes clear that he was without counsel at that moment and from all moments on. Because
But isn't it up to the court to make a determination as to whether a person is pro se or not, if they have a legal advisor or an attorney? It's
Okay.
the court's decision.
Okay, the quick answer to that is on November 3rd, the court made the statements I just talked about. On November 4th, when there was no Donnell Baines there because he was already sent to the grand jury, on November 4th, the court adjourned till November 17th and said it's for grand jury action. When they came back, they were never in the court between November 3rd and November 17th. When they came back into the court on November 17th, the court said on the record, it's the first time he'd seen Donnell Baines since November 3rd, said on the record, Mr. Baines is still representing himself. There's
So
no
isn't-
still except for November 3rd.
Isn't there an argument that that simply supports the fact that the court forgot to revisit it at that point, and that the argument, a better argument is that from that point going forward, the defendant was deemed pro se?
No, Your Honor, because if you look at what happened at the grand jury, when he came into the grand jury, the attorney who was with him was introduced as his legal advisor.
Can a statement without a court directive deem him to be pro se? Can that statement alone deem him pro se without the court having, at that time, not made a pronouncement
Okay.
or determination that he was in fact pro se?
It meant that he was without counsel in front of the grand jury, and nobody should have proceeded at that point when he was without counsel and there had not been a colloquy to determine whether he could go forward with counter.
How was he without counsel?
The district attorney herself said this person's here as his legal advisor.
Can the district attorney, by that introduction, cause that attorney to be a legal advisor and not an attorney?
The district attorney doesn't make that determination, but
And you agree that up to that point, the court had not so made that
up to
determination?
that point, the court had discharged his previous attorney, and there had been no new attorney assigned. He was without an attorney, and any district attorney who walked in that grand jury, she was present.
So
in
the
courtroom.
person he went in with from the 18B list got there because the court sent him there, correct?
And he understood he was sent there as legal advisor. Everybody understood that. And at that point, the district attorney would have had an obligation to say, wait a minute.
So there's no requirement that the court make a determination?
If he's,
So at that point, it's just based on the representation that the person was a legal advisor?
if he is at a critical stage of the proceeding and he does not have counsel, he has been deprived of his right to counsel, that proceeding becomes a nullity. And getting back to Your Honor's question of remedy, if the grand jury proceeding is a nullity, there can be no indictment. And with no indictment, there cannot be any subsequent proceedings. The indictment needed to be dismissed, and then the prosecution could have gone to the court and asked leave to present to to another grand jury.
Thank you,
Let me
counsel.
ask you, I have one more question, if you don't mind.
Go ahead.
So let me ask you, counsel,
You have
sorry,
one
one more question. Let me ask you the following. Suppose we assume that the judge, when he made the 18B, when he requested to get somebody from 18B, believed he was appointing Mr., I think it was Levine, I've forgotten his name, as his lawyer, as his attorney, not as, let's just assume that, okay? And let's suppose that the attorney believed he was the legal advisor. Where does that leave Mr. Baines in terms of whether he is represented by counsel or not?
He's not represented by counsel. If no one is there saying, I'm the attorney representing Mr. Baines, and the prosecutor knows that, she had an obligation to say, whoa, stop here. Let's go to the court and get the colloquy done and see if you can represent yourself here. It wasn't done. She introduces this person as legal advisor and then goes ahead and you know, tells Mr. Baines, okay, then the worst possible thing that could have happened for him happened. She reads the charges that are going to be presented to the grand jury, and he says, I take my Fifth Amendment right, I won't testify. So what the grand jury sees is he comes in, says I'm going to testify, want to give my statement. The DA confronts him with what the crimes being considered are, and he says, I'm out of here. I take my Fifth Amendment right, and I'm leaving.
Thank you.
Thank you.
Can you start there at the pro se discussion, please?
Sure, absolutely. So I'll take this in two parts. Stephen Wu for the people. One is that defendant was represented by counsel at the grand jury presentation. The appellate
And at
division.
the time that he appeared before the grand jury, had the court ruled
No,
that he
absolutely
would
not.
be pro se?
No, at the November 3rd hearing, the court made absolutely clear that it was not deciding whether to grant the pro se representation request and was just deciding an ATB attorney to be his counsel.
So
And
what about the claim that because there were representations made at the grand jury, and it did say legal advisor, that things should have been interrupted and they should have gone back before the judge?
Well, I think there are a few things to say about that. One is that the record is at best mixed here. Mr. Levine, the lawyer who was appointed here, said at an appearance on November 8th in criminal court that he was representing Mr. Baines in Supreme Court. That was the statement from the lawyer
That was on a
himself.
different indictment, right?
It was a different
In
indictment,
front of a different judge.
but he was referencing his representation of Mr. Baines in this proceeding.
Well, how do we know that?
Well, because he was appearing in criminal court to dispose of an earlier misdemeanor charge that was arising out of some of the same actions
So is it
here.
possible that he was the attorney for Mr. Baines in that action, but was a legal advisor in the other action?
I think that's not a fair understanding of that because that action was taking place in criminal court. That's what the appearance was. And what he said when he appeared there was, I am representing Mr. Baines in Supreme Court, which was this proceeding. So these are two different courts at the same time, and the criminal court action was being disposed of because it was superseded by this indictment. And that's a statement from Mr. Levine. The representation about being a legal advisor in front of the grand jury, that came as a question from the ADA to the defendant, and the defendant just said, yes, Mr. Levine himself did not represent that he was just a legal advisor then, as opposed to his counsel.
But he didn't say anything. He didn't say he was his attorney. He didn't correct the DA.
I mean, he didn't say anything in response to that particular exchange. It's not clear he heard it. He definitely appeared there, and he was advising the defendant during that time. So I think...
And after that, is it correct that there was discussion about defendant having the opportunity to confer with Mr. Levine?
Correct. So at a December 22nd appearance in front of Justice Wiley, there was a much longer colloquy at that time, and that was really before any substantive proceedings had taken place, about whether he understood his rights, whether he understood the perils of proceeding pro se. Justice Wiley specifically flagged the dangers of going pro se before trial when an attorney is needed to know the details of criminal procedure. And only after then did Justice Wiley confirm, fine, you were going to go pro se, and we agree that from that point onward, he was representing himself with the legal advisor.
Justice Wiley or Justice Pickholtz?
Justice Wiley was in December 2010. Justice Pickholtz did another pro se inquiry in April of 2012.
But it was done in a arguably piecemeal fashion. Would you agree?
No to this degree. The people's position is that Justice Wiley's colloquy in December 2010 was adequate for purposes of allowing him to represent himself. It targeted the problems, it asked defendant multiple times if he was aware of the dangers, and defendant made absolutely clear his desire to go
Did it
pro
make
se.
clear that the defendant wouldn't get to do his motions over, the court wouldn't assist him, et cetera? Those are the dangers that he faced by representing himself?
Correct. Justice Wiley said, Well, let me amend that a little bit. Justice Wiley said there are dangers with going pro se because you don't understand criminal procedure. A lawyer does. The judge did say you can file whatever you want and was very lenient to defendant, allowed him to file his motion. So there was not any restriction placed on defendant for his decision to go pro se versus being represented by counsel. So to that degree, he didn't warn him of those
Did the
dangers.
judge ever explain the difference between a legal advisor and an attorney?
The question came up in December, and Justice Pickholtz revisited it a little bit later. And part of the issue was that defendant himself had asked a couple of questions about the difference between the two. Because what he wanted, and this is why his request to go pro se was unequivocal, what he wanted was the ability to make decisions on his own. He did not want to be controlled by his lawyer. And I think what both Justice Wiley and Justice Pickholtz said was, if you want to do that, you represent yourself, all right? A lawyer otherwise will have some control over certain decisions, like appearing before the grand jury, and certain decisions like wish motions.
But wasn't the point in November, the judge was allowing the opportunity for defendant to have another conversation with a
Correct.
different lawyer to see if perhaps a different lawyer might agree with defendant's, let me call it decision, that he wanted to appear before the grand jury?
Yes, that is correct. And we don't know when that conversation took place or whether it did. What we know is that Mr. Levine was appointed after the November 3rd conference.
Something had to take place that he's in the grand jury.
Correct. Well, something took place, and then he appeared with Mr. Baines in front of the grand jury. Mr. Baines decided to testify and then pleaded the fifth. So,
So either this attorney is representing him and agrees that, with defendant that he should be testifying, or he's not his attorney, or he's a legal advisor, let's stick with that phrase, and the defendant has gone forward, pro se, to appear before the grand jury. Isn't that the only real option you have when you
Right,
look at
and-
that record? There's not another way to look at that.
well, and the record here supports the appellate division's finding that what happened was Mr. Levine was representing him, apparently persuaded by Mr. Baines
that a finding of
to
fact?
appear. Excuse me?
Is that a factual finding?
So it is a factual finding the appellate division made and is supported by the record here because at worst, there is a mixed question of fact about exactly what Mr. Levine's status was, and it's supported to say that he was his attorney rather than his legal advisor.
Counsel, I'd like to go back to something you just said, where he made clear he wanted to go pro se because he said he wanted to make the decisions himself. So if we get a case in the future and the defendant's arguing, I clearly said I wanted to go pro se because I said I wanted to make these decisions myself, you would say, yes, that defendant's right, and that triggered on the duty on the part of the judge to inquire and to do all the things we say that the judge has to do when someone unequivocally says they want to go pro se.
I don't
wanna
think it's
make
that
these
simple.
decisions
I'm really summarizing a longer discussion, which is part of the pro se colloquy here between the judge and the defendant, where defendant made clear what he wanted to do. The judge was explaining many of the things that you want to do can and should be done by an attorney. The attorney will file your motions. The attorney will help you with whatever. And the defendant still said, knowing all of that, that he wanted to go pro se. So I'm really maybe mistakenly summarizing too simplistically a much longer conversation between the judge and the defendant here. But I'd like to return, if I could, to the warrant question
Yes, please.
before I run out of time. So this court should reject defendant's challenge to the July 15th warrant for three reasons. One, it wasn't preserved below. Two, the warrant, with or without Detective Turk's affirmation or affidavit, was sufficiently particular. And third, any defect was harmless in any event because of the other evidence in this case. On preservation, the omnibus motion by the defendant did not flag in any way the specific objections raised here. One, it did not complain about considering the affidavit with the warrant. And two, it didn't object to the purported absence of the
warrant on
crime.
its face was not sufficiently specific, right?
It did not. It did not. So this is the critical point for the preservation argument. The argument made in the omnibus motion actually relied on the fact that the affirmation talked about the crime of kidnapping, because the particularity argument made by the defendant below was that there wasn't a showing that the items listed in the warrant had anything to do with the crime of kidnapping. And that's why the
omnibus motion says, and I think counsel had quoted it, it was constitutionally overbroad in that they failed to describe with sufficient particularity the property to be seized.
Well, so that's on page 68, which is, I think, fairly described as a boilerplate legal language for it. On pages 69 and 70, in talking about the July 15th warrant specifically, because there are a couple
That's
of
actually on
warrants.
page 53. 68 has a different statement that also helps the preservation.
Well, I apologize. But in talking about the July 15th warrant specifically, the argument that defendant was making was that the allegation of kidnapping does not support any search for these items because these items were not used for the
That's an
kidnapping.
additional argument he made. But there's a blanket claim that on its face, it's not particular. Does he have to cite Grow to preserve Grow?
The defendant has to do two things here in order to make these arguments here. One is to complain about considering the affidavit in conjunction with the warrant.
Well,
Defendant does not say
wait
that.
a minute. Why
Does not
can't-
say that in the
So
motion.
in your view, it's not sufficient for him to say the affidavit on its face is not sufficiently particular, and for the people to come back and, not the affidavit, I'm sorry, the warrant on its face, for the people to come back and say, wait, the affidavit supplements the warrant, which I don't think they said.
The people did not say that because the omnibus motion did not make that argument. So here's what happened. I think if you look at the argument specifically about the July 15th warrant, the defendant says the items here were not used for purposes of a kidnapping. And that is why the judge, in determining this omnibus motion, didn't address the issues of incorporation or reference or attachment,
I think
but
he did.
instead
He relied
said,
on the affidavit. Almost,
Excuse
he relied on the text of the
correct,
affidavit over and over and
because
over.
he thought his task was to establish whether, contrary to defendant's arguments in the omnibus motion, there was support for these items being used for the kidnapping. And that's what the judge held in the omnibus motion.
Then why isn't that reaching the issue? Why isn't
Because
that good enough for
it's-
preservation?
Because it's not addressing the objection, which is you can't consider the affirmation at all, or the affidavit at all. And that's the argument that's being made here, is the affidavit should just be ignored for purposes of considering the sufficiency of the warrant. And the separate problem, too, which was that there was not a specific objection to the fact that the warrant didn't include the specific crime, again, because the defendant below made arguments about the crime from the affirmation here.
But couldn't you take that argument to be, if you had put in your search warrant, go get handcuffs or ties, or, you could assume from that, okay, we pretty much understand what we have to get, and it's, but putting these broad categories of those things in there without saying they were related to a kidnapping, they don't shout, hey, this is what you have to get. They're not specifically described enough without the charge to know what you should take.
So I think that would be a generous interpretation of the omnibus motion, but if I could briefly address just the merits of that argument, because even without the affirmation here, which again only contained the crime, the warrant here was sufficiently particular on its face as well. Much of the language here was about specific physical items, often identified with great particularity, such as a phone with a certain color, a bag with somebody's name on it, a birth certificate belonging to one of the victims in this case. There's no need for a crime to be listed in order for police to be able to identify those items and to be restricted in which items they
There's
can
one
obtain.
subsection, I think, in your brief, at least, you concede is overly broad.
Correct. The very last one, which is about any computer-related equipment, but for that one, only a couple of physical items were recovered, a router and a mouse, I believe, and none of them were used at the trial, so it doesn't matter.
Nothing seized from that paragraph came in at trial?
No, I believe it was introduced at trial but not relied on for the prosecution. And I want to be clear, there is some language in the earlier provisions about computer equipment, I think about cellular telephones, but all of those ended up being used just to seize particular physical items. Much of the content from the 2 laptop computers that were recovered from this warrant were recovered as a result of a subsequent warrant on July 28th that authorized the search of those computers for specific items. And so the content for those computers, as opposed to the physical fact of those computers, is just not at issue in this appeal.
Is it clear from the record that they weren't viewed, that the content wasn't reviewed before the subsequent warrant was obtained?
Nothing in the record indicates that they were searched before, and the description of the need for the July 28th warrant, I think it's fairly read to say a search hadn't been done because they were seeking judicial imprimatur for a search of those computers for specific items on them.
Thank you, counsel.
Thank you.
If I could jump quickly back into the counsel issue and a few of the dates that were mentioned. The 11/8/2010 proceeding in front of criminal court, as Your Honors have already noted, wasn't the same case. And secondly, it's at pages 2410 through 2412 of the appendix. And if you look at that, you notice that Mr. Levine came in and says, I represent Mr. Baines in Supreme Court. I have no idea what he meant by that. I don't know if he was trying to say I'm legal advisor. But what's important is They don't produce Mr. Baines until after he made that statement. If you look in the middle of page 2411 in the appendix, they don't produce Mr. Baines. He's not in the courtroom when Mr. Levine said that, so he had no idea that was being said about him. This guy's, and it's interesting, the very next day, or the very next time that Mr. Levine was in Supreme Court, he introduced himself as a legal advisor. He didn't introduce himself as being the person representing Mr. Baines.
Doesn't this really beg the question that we don't really have a record that we could review with any intelligence what happened?
It says we have a record that shows he was not represented by counsel. That's what we have. We have a record where everybody was passing the buck. No one said, hey, let's have an affirmative statement. I mean, before the grand jury, there was no colloquy about pro se, none whatsoever. And then he walks into the grand jury. Everybody understands in the grand jury that he's representing himself. And then the very next time he's in Supreme
Except
Court.
there was a discussion prior to him going to the grand jury. In fact, it was precipitated by his insistence that he wanted to testify in the grand jury. The court gave him a new attorney and said, I'm going to revisit the pro se issue, but did not make a determination that the defendant was pro se before he went in that grand jury.
The court did not say you're pro se, but when he walked into the grand jury, everybody there, including a representative of the government.
And you're saying that's enough?
I'm saying that's allowing him to proceed without counsel.
Thank you.
Can you just address, the red light is on, just very quickly, the point that it's on the warrant, that any defect was harmless? Is he right? No harm, no foul?
The July 28th warrant, the authorities already had in their possession since July 15th all of the material that was seized, all of the electronic material was seized, and they were authorized by the July 15th warrant to take every single bit of data that was stored in that electronic equipment. And we have no idea if they went into that equipment in between July 15th and July 28th, but it doesn't matter. They had already improperly seized it on July 15th. You can't fix it with the July 28th warrant.
If it authorized the seizure of this specific computer, let's say hypothetically, this computer, they even have the serial number, and it's just a seizure, that would be too vague? And they're not authorized to go into it, they have not gone into it, they're just authorized to seize it.
But that is...
Hypothetical.
Hypothetically, if all it said was, here is a specific computer, take this specific computer and bring it back to the precinct.
Right.
Okay. And doesn't say anything to do with it. Possibly that, it's still got the Groh versus Ramirez problem. It still has it. But that's a different situation than what happened here. They went in with a warrant that authorized them to take every single bit of data out of every single piece of electronic equipment that was seized, and they didn't come back and fix it to the extent it was fixed on July 28th. We have no idea what happened with those.
But I thought in part his argument, I may have misunderstood him, on the harmlessness was that the prosecution didn't really rely on what they concede was not particular. It was overbroad.
The sentence that they concede is overbroad is the sentence that authorizes taking computers. And then after that, the warrant then says what you can do with the computers. And what you could do with it is take every single bit of data that's in them.
But I think what they're saying is the catch-all computer phrase or line is overbroad, not the earlier language that specified certain devices, phones and computers, I don't
Well, the
recollect.
earlier language said 2 computers.
So I think their harmless error argument is it's harmless to the extent we took things pursuant to the catch-all, because it was a cord and a router, and although
One
those
thing,
probably went in a bag, no one used
you
them.
don't know what the police doing the seizure were thinking. They may have been
If it
thinking,
says
we're
take
taking this...
X computer, that's this serial number, and
But
then
it-
there's a catch-all, you would think they took X computer with that serial number pursuant to the provision that said you can take X computer with the
It
serial
didn't
number.
say X computer with a serial number. It said 2 laptops. It didn't give any further
Give the
identifying...
make or
Didn't
something.
it give the manufacturer of the laptops?
The second, the July 28th did. This one just said two laptop computers without any further identifying. But again, it's not the hardware we're talking about. It's what's inside the hardware. And they were authorized without any limitation, without any reference to any crime. They were authorized to go in and take,
After filing a subsequent warrant, though, correct?
But we don't know that that's when they went in. It's very interesting. The prosecutor's witness who actually took the data out of the computer, Mr. Faramis, not once during his testimony did he state a date where he did it.
Does that not go to the record issues that were raised just a moment ago? It's that the record here isn't very well developed in terms of whether there was this violation that you say?
Well, if we're talking about the validity of a computer, the prosecution has the burden in the initial stage to show that they were operating under a valid search warrant. That some burden may shift to the defense after that, but they have to show initially that they were operating under a valid search warrant. And if they went into those computers before July 28th, they didn't meet a burden of showing that they didn't go into them.
And you're correct, it is 2 laptops, that the phone is described.
I guess I thought your argument was a little bit simpler, which is, if they'd broken into Mr. Baines' house without a warrant and taken the laptops, it doesn't matter if they get a later warrant to search the contents. And so going in with a warrant that is invalid, if it is, I'm not saying it is, but going in with an invalid warrant to get the laptops is no different than breaking into his home.
Absolutely.
So I don't know what the second warrant really does here.
As Gross says, warrantless searches are presumptively unreasonable, and a search done without a valid warrant is unreasonable.
Thank you, counsel.
Thank you.